All right, good morning, everyone. This is case CR 22-211623, State versus Chad Guy Daybell. Mr. Daybell is present, represented by his attorney, John Pryor. The state is also present, too, with prosecutors. Ms. Lindsay Blake will be arguing, I understand, on behalf of the state at the hearing today. This matter is being recorded on the court's FTR system, as well as this Zoom hearing. We're conducting it remotely. It's also being live streamed on the court's YouTube channel for public access to this hearing. At this time, then, the court has scheduled for this morning a motion to sever. The motion to sever was filed on the 9th of September 2021. Thereafter, a brief in support of the motion to sever was filed on February 9th. The state filed a brief in objection and opposition on February 24th of this year. The court would note that on May 25th, 2021, in this case, a single indictment was filed in the case, which included charges against both Mr. Daybell and also Lori Vallow, including multiple counts that have conspiracy charges. And so the court has previously gone through and ruled that the cases are joined pursuant to Rule 8B of the Idaho criminal rules. And so this motion for severance was made with the defense request that the case or the defendants be severed. So at this time, Mr. Pryor, are you ready to present argument in support of your motion?
Yes, Your Honor.
Okay, you can proceed with your argument.
Thank you, Your Honor. Judge, in this particular case, the two cases, as the court pointed out, were joined by this court. Subsequent to that, there was an order that put a stay on Miss Lori Vallow's case. I am not afforded the opportunity to get any information about the status of the Lori Vallow Daybell matter, and I don't have information as to what her status is. However, I do know that the stay is still in place, and I've not yet seen a transport order that would transport Miss Vallow Daybell back to Madison or Fremont County. I can only presume at this point, Judge, that there is still a stay and that there hasn't been any determination by this court as to what's going to happen in her case. The reason that's concerning, Judge, is that we do have a trial that is set for January. I think it's January 9th of next year, and it's fast approaching. There's a significant amount of preparation that needs to be done, and that preparation is going to include whether or not the cases are severed or whether they're joined together. And I'm not going to get into tactics, but I can assure the court that there is going to be a significant difference between how I prepare in the event the cases are joined as opposed to whether they're separate. In addition, Judge, I noticed that Ms. Blake in her response said that the only issue is Miss Lori Vallow's mental state. If you look at my pleadings and you look at my motion, Judge, I also made note of the fact that there are some additional charges that arise out of Arizona. Those are charges that Mr. Daybell, at least if I believe what the press is saying and the prosecutor, Mr. Daybell has is not being considered for prosecution in either of those cases, although Miss Lori Vallow is. My concern is that there's a lot of evidence, Judge, and with this court putting the limitation on my ability to discuss specific facts as to what facts I want to rely on to say this is why it needs to be severed, I put in a blank way, Judge. I said, Judge, I'd like the prosecutor, and under the rule, be required to provide their exhibits that they intend to use and allow the court, if the court needs that, to make an evaluation as to whether there is a significant conflict and whether or not it would have some sort of prejudice in either side, be either Mr. Vallow or Mr. Daybell presenting their case.
Right.
So it's not
on that point, the rule doesn't indicate anything about exhibits. The rule is pretty narrow in scope of what may be provided in support of a relief for prejudicial joinder under Rule 14, and that's whether or not there are any statements or confessions. It's narrowed in scope to that is the way I read it, and I think the way the case law interprets it.
And it is, Judge, and the rule says the court may. It doesn't require the court to turn over the statements But I guess the word exhibits, I guess I intended to mean in terms of statements or confessions or items of that type of matter. So my motion.
I guess on that point there, then the state has indicated that you've been provided most of or all of the discovery at this point. And I guess getting right to that issue then, if there are any particular statements or confessions that are involved in this case, I would think those would be something the court would consider, but I've not received any notice of any of that.
Okay, and Judge, I guess I would refer the court to the rule. And the rule doesn't say provided to defense counsel. That's correct. I've been provided the majority of the discovery. There are some issues as it relates to that, but the rule says that the court may request that those statements be provided to the court. It does not say it's provided to defense counsel. It says provided to the court for the court to make a determination. So the rule does allow the court to require the prosecutor to turn over those statements. But Judge, the issue still primarily is the issue of the mental capacity of Ms. Vallow. So given that, Judge, I'll defer to Ms. Blake and allow her to make her argument.
All right, thank you, Mr. Pryor. Ms. Blake, argument from the state, please.
Thank you, Your Honor. And I think to start off with, what the state would indicate is we do recognize that we are arguing the motion to sever today that was filed by Mr. Daybell. However, the state is requesting that the court reserve ruling on this matter until more information is available to the court and the parties regarding the stay in the co-defendant's case, which these are one case for trial. So when I say the co-defendant's case, I'm simply referring to Miss Lori Vallow Daybell's case, which is Fremont County case number CR 22-21-1624, and it is the companion case for trial. It is the state's position that it would be most appropriate in the interest of judicial economy and to preserve all rights of the parties that Ms. Vallow Daybell also be allowed to be heard regarding a motion to sever, since this also affects her trial rights. That being said, we are not asking for an indefinite delay on any ruling from the hearing today, but we feel that any information that may be available to the court and the parties, hopefully fairly quickly, would be useful in making a decision regarding the severance and also wouldn't infringe upon the rights of either of the defendants in this matter.
Okay. So let me address that point then. So regardless of her status of competency or not, I assume that hasn't changed the evidence you've got in the case. And I guess the issue here is whether or not there are statements or confessions which you think the court should review in order to make a determination under the rule. And I do agree with Mr. Pryor. The rule pretty clearly states that if that's going to be ordered, that it's ordered that the attorney for the state deliver to the court that information. And of course, that's not something that would need to necessarily be disclosed here in public, and we could have a sidebar, but I do want to know whether or not there are statements or confessions that need to be considered in making the determination, and not learn that at the time those are coming up at trial. So in your evidence, do you believe there are any of these statements or confessions which go to the Bruton issue and many other issues which require me to weigh that out to make a decision?
Your Honor, the state does not believe that there are any statements. We do not have any statements that we intend to use at this time that would fall under the Bruton rule as the state understands it and has reviewed the case law. As the state indicated in our brief, we have provided voluminous discovery to Mr. Pryor. We provided everything within the state's possession at this time. Of course, discovery can be an ongoing process, and this could change at some point, but at the current time, there are no Bruton issues. There are no statements that the state intends to introduce which would trigger a Bruton issue. And so what the state had pointed out in our brief is, while we recognize that Rule 14 can place that burden on the state, I don't think there's been any indication by the defense or a real issue raised with regard to the defense believing that there are Bruton issues in this case or any statements, and they have access to the statements that we have access to. So from the state's perspective, no, there are none, and the defense already has the statements that the court has in our possession. When we look at the cases that delve into that Bruton issue, Can indicate at this time we do not have any custodial statements. So at no time after the parties were Mirandized do we have any incriminating statements one way or the other, which we would intend to use. At this point in time, well, we wouldn't intend to use them because they simply don't exist at this juncture. And again, of course, that could change. It's always an evolving issue, which is part of the reason the state thinks it may be beneficial to preserve the ruling on severance, since a motion to sever can be raised anytime before trial. And and as this case evolves, we recognize that it could go one way or the other. In addition to, if the court is inclined to make a ruling at a sooner period of time than the co-defendant, Ms. Vallow Daybell's case can move forward, we think it would be appropriate for any ruling to be made without prejudice to allow the parties to re-raise the issue. Ms. Vallow Daybell may or may not want to raise the issue, and depending on where her case heads, the state may or may not feel that it is necessary to re-raise the issue, or depending on the outcome, if there is more information gained down the road, Mr. Daybell may want to re-raise the issue depending on the ruling of this court. So we would be requesting that just at the outset. And I don't know if the court wants to hear the argument regarding the severance itself, or if we were just addressing whether or not the statements needed to be turned over.
Yeah, I interjected with that issue, but I would like to hear the remainder of your argument on the severance motion.
Thank you, Your Honor. And the state did file quite a lengthy brief in this case, and so I don't want to belabor those points too much. But the state's position in this case is the first thing that we start with is under the Rule 8, and this court has already indicated these were joined under Rule 8B. It's the state's position that these were properly joined. I think this court, in its August 6th order and at subsequent hearings, has made indication that the joinder in this case under Rule 8B, when we're dealing with the co-defendants, was permissible. If it's been determined that under Rule 8B, a joint trial is permissible, a defendant can always raise a severance under Rule 14, arguing that the joint trial would be prejudicial. And that appears to be what the defendant is arguing today. However, case law makes very clear, and looking specifically at State v. Gamble, 146 Idaho 331, it states the defendant has the burden of showing such prejudice. When we delve further into the case law, and the federal courts seem to deal with this issue more so than the state court, at least the Idaho State Court, the Supreme Court has also addressed it. And in United States v. Fair, in United States v. Contreras, that is not the right citation. I apologize, Judge. As the federal cases go through this, though, I would indicate that Federal Rule 14 is worded very similar to the Idaho rule, providing that the court may order separate trials of counts or sever the defendant's trials or provide other relief that justice requires if there is prejudice. In Richardson v. Marsh, 481 U.S. 200, the United States Supreme Court has found that joint trials serve the interest of justice by avoiding the scandal and inequity of inconsistent verdicts. That joint trials also enable a more accurate assessment of relative culpability, advantages which sometimes operate to the defendant's benefit. And in addition, joint trials avoid prosecutors bringing separate proceedings, presenting the same evidence again and again, requiring victims and witnesses to repeat the inconvenience and sometimes trauma of testifying, and randomly favoring the last tried defendants who have the advantage of knowing the prosecution's case beforehand. The defendant, the Ninth Circuit Court of Appeals, has stated the defendant bears the heavy burden of demonstrating that the joint trial was so manifestly prejudicial as to require the trial judge to exercise his discretion on the motion to sever in just one way, by ordering a separate trial. And as we continue to go through the case law continues in both the Ninth Circuit, the federal courts in general, the United States Supreme Court, and the Idaho courts continually indicate that the burden is on the defendant, that it is a significant burden, and especially when we're dealing with cases of conspiracy. In cases of conspiracy, joinder is favored. The reason being, again, for judicial economy, we are dealing with a lot of the same witnesses, the same evidence, and there is overlap. The courts have even found that joinder is favored so strongly that even if at the end of the day, the charge itself that would require the joinder, so such as a conspiracy charge, even if a defendant is not found guilty of that, it does not make the joinder improper or a court's decision not to sever suspect in that particular situation. I think Mr. Pryor had indicated that the state raised that the only issue dealt with Ms. Vallow Daybell's mental health. That issue wasn't actually raised by the state. Where the burden is on the defendant, the state has simply responded to the brief and to what appeared to be the arguments that would be made by the defense today. In the brief, there were no specific issues outlined in defendant's brief. It appeared that there were some things alluded to. One of those appeared to be the stay in Ms. Vallow Daybell's case. It is the state's position that it is inappropriate to consider the stay in her case as a reason to sever at this juncture. Again, these cases have been on separate tracks, so Mr. Daybell has had the opportunity to be heard and to file motions, while Ms. Vallow Daybell at times has not had that opportunity yet to be heard on some of those motions, which is part of the state's rationale for asking that any decision in this case be reserved. But regardless, we believe that until a decision on the stay in her case is made, it would be premature to factor that into a decision to sever the cases. And when we look at some of the cases in the federal system, they deal with this issue and they talk about, I was trying to get to the exact case, but it's in our brief, and they do talk about the stay in a case being attributed to all the co-defendants potentially and accounting against their speedy trial clock in the federal system, which is calculated different. But the courts go on to talk about under the United States Constitution that can be a factor, but that it is not necessarily a violation of a defendant's right to continue their trial in order to have a joint trial with a co-defendant. And it would be the state's position in this case, and I think we've raised this before, but with regard to any speedy trial issue and the right to speedy trial of a defendant, Mr. Daybell, expressly waived his right to a speedy trial. He filed a signed written waiver of speedy trial. And in Idaho, the courts have found that once a waiver of speedy trial occurs, that issue cannot be raised down the road as an issue for a delay in a trial or a reason why the trial hasn't been held faster. And I did find the case that I was referencing. So United States v. Vasquez, which is 918 F2D 329. It's a Second Circuit case, but they refer to the Speedy Trial Act in the federal system that imposes a unitary time clock on all co-defendants joined for trial. United States v. Pena, 793 F2D 486, another Second Circuit case, finds as a result, delay attributable to any one defendant is charged against the single clock, thus making the delay applicable to all defendants. So they found that basically if a defendant brings a motion to sever, which is denied, a reasonable delay analysis is applied in determining the reasonableness of any delay. Even under this standard, several federal courts have found delay alone isn't enough to establish prejudice. And again, what they continue to come back to is that joinder of trials is favored. They have found judicial economy is paramount and that the state should not be required to bring forth the same evidence in multiple trials when it could be done in just one trial. And in United States v. Casas, it's a Fifth Circuit case, 425 F3D 23. They found because the general rule is that those indicted together or tried together to prevent inconsistent verdicts and to conserve judicial and prosecutorial resources, severance is particularly difficult to obtain, whereas here multiple defendants share a single indictment. They went on to find that one of the defendants that had attempted to have his trial severed, that even though his trial may have been speedier had it been severed, the delays did not cause significant prejudice nor did they result in the denial of a fair trial or a miscarriage of justice. They went on to just state the appellant must show prejudice greater than that which necessarily inheres whenever multiple defendants are tried jointly. And in this case, I think there's just some potentials thrown out by the defendant. I don't think there's been a definitive showing that there is any prejudice. I think one of the arguments here is the delay, but I think case law favors that delay alone is not enough to sever a trial. And the state in no means believes that the trial should be held in perpetuity, but we have a trial date right now. There's been no indication that Ms. Vallow Daybell is going to ask to continue that if it turns out that she is able to proceed forward. In addition to that, the defense has proffered to the court or indicated that there is a chance that some evidence may be attempted to be used against Ms. Vallow Daybell that deals with some issues in Arizona, and saying that if that were used, it would be prejudicial against Mr. Daybell. I think that's premature at this point. It's just an assumption or a speculation that that could happen. There are other appropriate ways to deal with that to determine if there is going to be evidence, such as a 404B motion to determine if it is applicable, if it is coming in, and if so, who that evidence would come in against. There are other things that courts have done to make sure that they're protecting one defendant's rights when there are joint trials. There have been cases in Idaho where a dual jury trial system has been used. There is case law saying that a dual trial system is not necessarily favored, but that it is not necessarily wrong to do that either. There are also times where maybe there are limiting, especially what we see as the most common remedy and what the courts have favored is limiting jury instructions. And they have found that the benefit should be given to jurors that they will follow those instructions. We shouldn't simply say that a limiting instruction, there's no way that it would be good enough. And so I think right now with the minimal issues that have been raised at this point regarding any potential evidence, they're hypothetical at this point. We don't know. And if there were to be any evidence that would come in only against one defendant, the courts have consistently held, and it's outlined in our brief very specifically, that a limiting jury instruction is favored and is often plenty to cure any of that. And it has been used repeatedly by courts to deal with that issue when evidence would only be applicable to one defendant and not the other. Obviously, the other concern, as we talk about judicial economy, I think one of the things that we would point out as well is in a case of this magnitude, requiring the state to present two different trials obviously would have a significant impact with regard to costs for the counties involved, as well as time for all the witnesses. This is a trial that has been set for 5 weeks. The anticipation being that 2 of those weeks will be for jury selection and another 3 for the actual duration of the trial. If the state were required to replicate that same trial, obviously we are looking at the potential for another 5 weeks.
It's actually already set for 10 weeks, I believe.
Oh, 10 weeks. I apologize, Judge.
All right.
I was definitely shortening that down. Yeah. So I appreciate that correction. And I think, so with that, we would be looking at the potential for 20 weeks that the state would have to replicate the same evidence, essentially, require us to call all the same witnesses, require us to use all the same staff and resources to do those trials. So I think that judicial economy definitely plays into this case. I think as outlined in the rules, the burden is is clearly attributed to the defendant, and it is a heightened burden to show that the only remedy would be to sever the trials. And it is a pretty, it is a unique remedy considering what the courts have put out. In addition, one of the most common things that the courts look at, as the court already raised the Bruton issue, and I think we've addressed that. We addressed it both in our brief and here today in indicating there simply is not a Bruton issue at this juncture. The defense has not raised a Bruton issue. They have the statements. Obviously, as I indicated, discovery is ongoing. If at any point statements are obtained, the state recognizes our requirements to immediately get those turned over to defense. And again, we recognize that that could raise a different issue, and we would need to deal with that at that time. The other thing that the state would indicate is a reason for severance or has been found as a reason for severance is if the defenses are completely antagonistic. In this case, there's not even been an argument or an issue raised with regard to the defenses being mutually antagonistic. And we outlined in our motion as well, but the courts have held that for them to be antagonistic is more than just defendants having a different take on the case, but that most courts have held that the defenses have to be so antagonistic that in order to find one party guilty or one party guilty, the other party would have to be innocent, or vice versa. That it is such that if one defendant essentially puts on such a great defense, or that the evidence is not there to convict them, that it automatically convicts the other defendant. So those have happened in cases in which both defendants essentially claim it was the other one, and there's nobody else that it could possibly be. However, courts have looked at cases in which defendants have pointed the finger at one another as being the culpable party, but there was a third party involved. And the courts have found that by having that third party involved, simply pointing the finger at each other and blaming each other does not make the defense mutually antagonistic, because a jury could rationally and reasonably find that neither party was guilty. They don't simply have to find if one's innocent, the other is guilty by believing the evidence presented to them. They could believe that it was a third party or the other individual. So even if an antagonistic defense were raised in this case, unless it's to the extreme, it does not necessarily require severance. So I think given that, it appears that, again, the main arguments raised by the defense is that there's the potential for some evidence to be admitted against Ms. Vallow Daybell, which would not be appropriately admitted against Mr. Daybell. I think the case law clearly supports that if that is the case, the state can simply provide an appropriate jury instruction, limiting jury instruction with regard to that. And then it appears that the main crux outside of that would be whether or not there is prejudice based on a delay of the trial. And again, the state's position is when you're dealing with co-defendants, the federal courts, and again, we recognize they have a different clock, but they have established that the clock counts against both defendants, that there may be delays by some defendants, but that those delays alone are not enough without a showing of how it actually is going to prejudice the defendant. I don't think the defense has even put on any kind of argument or evidence today that even if the trial were to be delayed, which that's not where we're at this point in time, but even if the trial were to be continued, I don't think there's been any showing of how that would delay the defendant. There's been no argument that it would change the evidence, or that it would require that, or that they would lose evidence, or that there would be anything else which would require such extreme prejudice to force a severance. And again, part of what the state's looking at there is there has been a written waiver of speedy trial filed in this case. And with that waiver of speedy trial, Mr. Daybell has waived the right to essentially use that as his argument. And that is in State v. Youngblood 117, Idaho 160. And it was the Idaho Court of Appeals. They state, an unequivocal written waiver of speedy trial signed by a defendant is dispositive of a later motion to dismiss on this basis. So I think if that's going to be part of the argument is the delay, the fact that we have that written waiver of a speedy trial actually indicates that that would be an improper reason to bring a motion to dismiss down the road. And the state feels it would be an improper argument as well for why a severance would be necessary or why it would be prejudicial. And I guess the last thing with regard to the speedy trial is I would indicate that there has been a test set out. It's a 4-factor balancing test. It was set out in Barker v. Wingo, 407 U.S. 514, to determine whether speedy trial rights have been violated specifically. And it indicates the court must balance 1, the length of the delay, 2, the reason for the delay, 3, whether the defendant asserted the right, and 4, the defendant suffered prejudice as a result of the delay. So at this juncture, there is no length of delay. There has been no request by Ms. Vallow Daybell to continue the trial. We are unsure of the status of her case, but there has been no delay based on that. Because there's been no delay, we don't have a reason for a delay. The defendant, whether or not he's asserted the right, he's actually waived the right. So number 3, we know the answer to that one, and whether he suffered prejudice as the result of a delay. Because there has been no delay at this juncture, he has not suffered any prejudice. So again, any argument with regard to a delay in the case is premature at this point, simply based on the fact that Ms. Vallow Daybell's case, or her case number has stayed, her trial remains set for January, the same time as Mr. Daybell's case. So given all of those reasons, the state believes that the defense has failed to meet any burden the heavy burden that they have under Rule 14, especially that heightened burden when we're dealing with conspiracy cases, since conspiracy cases more so are favored to be joined for trial. And given the considerations in looking at the interest of all parties involved, which the courts have looked at previously, in the interest of keeping trials together, we believe at this juncture it is more appropriate that the trials remain together. Again, the state recognizes severance is an issue that may be raised at any juncture. We are asking that if there is a decision issued, first we are asking that the court reserve ruling on it to allow Ms. Vallow Daybell to weigh in, because whether or not the case is severed affects her trial rights as well. If the court is inclined to issue a ruling before then, we are asking that it be done without prejudice, and that's to preserve all the parties' rights in the case. Again, as the court brought up the Bruton issues, at this juncture, there are none. We recognize that's evolving. So it's also we would feel that it would be fair to have that be without prejudice with regard to Mr. Daybell as well. If new evidence or information is raised, we understand that all parties may need to be heard on different issues again. But again, we believe it would be premature to make any ruling based on hypothetical evidence that may or may not be asked to be entered without any kind of decision as to who that evidence would be applicable to. In addition to the fact, we believe it's premature to make any ruling with regard to a delay or prejudice with regard to a delay, since there has been none at this point in time. So I believe that concludes the state's arguments, unless the court has any questions.
All right, thank you, Ms. Blake. I don't have any follow-up questions for you at this time. Mr. Pryor, would you like to make any rebuttal argument?
Judge, just very briefly, I've also taken the opportunity to look at the case law, and I want to make a differentiation between a couple of things that Ms. Blake had mentioned. There is a big difference, Judge, between a delay, which is referenced in every case Ms. Blake talks about, and uncertainty. And there is a difference between delay and uncertainty. And in the case of Ms. Vallow Daybell, there is uncertainty. We don't know what's going to happen in the future. Now, I would remind the court that my recollection, and the court, please correct me, but my recollection is the motion to sever was filed, I believe, in September. I believe that's when I filed this. So for the month of September, October, November, December, January, February, and now we're into March, that uncertainty has stayed there. Now, Mr. Daybell has been in custody, and I understand Ms. Blake is saying that a waiver of speedy trial is not prejudicial, but that only applies towards a delay. That case law does not apply to uncertainty. And uncertainty means that we don't know where we're going to be in a month, 2 months from now, and potentially 6 or 8 months from now. And the time to find out whether or not we're going to trial in January of 2023 is not the beginning of January of 2023. And Mr. Archibald is not able to file anything. Ms. Blake has said, well, Ms. Vallow Daybell's attorney could file things. No, he can't. He's not allowed to file anything during the stay. He can't file a motion to sever. He can't file a motion to change venue. He can't file a motion to continue the trial. He can't do any of those things. He has to sit there and wait like everybody else and find out what's going to happen in her case. And that's the uncertainty. And that's where the difference is, Judge, is the amount of uncertainty. Now, with all respect to Ms. Blake, I don't have to accept her position that there's no Bruton issues. I'm aware, when looking at the evidence, that there are a number of instances where Ms. Vallow Daybell makes statements to the police and other folks. And there are a number of instances where Mr. Daybell was interviewed by the police. And I'm not allowed, given the court's current order, to go into detail. So it seems a little disingenuous that they're going to say, well, you haven't provided any facts. Well, I'm not allowed to provide any facts because I'm not allowed to talk about the discovery, which is why I asked specifically that if the court feels that the uncertainty is not enough to sever these cases, then maybe the court should ask for the prosecutor to turn over all of the statements that they intend to use for trial, and the court can make its own independent assessment.
Okay, Mr. Pryor, I want to make a correction there. You're not prohibited from talking about the evidence to me. It's prohibition to third parties.
And Judge, this thing is being broadcasted on YouTube. And if I make a statement on YouTube about the evidence, I believe I'm in contradiction of this court's order.
Well, and you would be, and that's why I raised the issue earlier, that if there are specific issues we need to discuss outside of the public purview, then we can simply conduct what's called a breakout room on Zoom or a sidebar that's out of the presence of the general public.
And my preference, Judge, and I put that in the motion, is that the court would require the state to turn over all the statements, and I would defer to the court's wisdom as to whether or not they feel there's any Bruton issues, which is how I thought Mr. Daybell and I discussed how we would like to handle that. But it still goes back to the original argument, Judge. The uncertainty of what's going to happen in Lori Vallow Daybell's case is a big difference than the delay of any trial. So at this point, I would ask the court to issue a severance order, sever these cases. And I don't want any delay, Judge. We need to have some sort of certainty, just like some of the other motions coming up. We need to know how we're going to be handling this case, and we need to know relatively quickly. We are 9 months out, and there needs to be some certainty as to which direction we're going to go, whatever that decision is by this court.
All right. Thank you, Mr. Pryor. Ms. Blake, if you have any brief counter rebuttal, you can offer that at this time.
Thank you, Your Honor. I think the state would just, again, and I think that the court's already inquired of the state, we do not have any statements in our possession. When you look at the Bruton case law, we don't have the type of statements that are addressed by Bruton. As Mr. Pryor indicated, he is in possession of multiple statements. I think Rule 14 from the state's perspective does not call for or require the additional burden on the state for us to compile any and every statement that a defendant may have made to anybody, to any third party or any witness that the state would intend to use at trial. I think when we provide discovery, there's the assumption that the state may intend to use any of that discovery or evidence at trial. Mr. Pryor's already indicated he is in possession of those statements. So I think the defense already has any statements that they may be concerned about, which I think we could go out of the public purview to talk about any specific statements if he wants to address those with the state. We are not aware of any that we believe would arise to a Bruton issue. If Mr. Pryor feels different, it sounds like he's in possession of those statements already. And I think we could discuss them off the record so that the state could be aware of them. I don't think Rule 14, though, calls for or requires that the state have any additional burden added, that we essentially prepare every statement that we may want to use at trial at this juncture and provide them to the court. If the court were to require that of the state, I would indicate, given the voluminous amount of discovery and the multiple statements that may have been made to third parties or any individual in this case, would take the state a significant amount of time to delve through again to make sure that we did not miss any statements. But again, none of those statements involve Bruton issues. So I think it would be an extra burden on the state to require that. But if so, then we would need to request that we set these proceedings out a significant period of time to allow the state to make sure that we review all discovery thoroughly, to make sure that we don't miss any potential statements that we'd have to guess that the defense may think are somehow incriminating or would trigger the Bruton issue. So if the defense is in possession of those, I think we could go out of the public purview and talk about those, or they could be provided by the defense to the court or the state, so that the state is aware that they consider those concerning, and or the court. I don't think Rule 14 prohibits the defense from providing statements that they have concerns about, but the state simply has none at this juncture. And then I would just indicate, just to clarify, the state has not indicated, or if there was an appearance that we indicated that Ms. Vallow Daybell's attorney could file anything at this juncture. We did not intend to indicate that. The state is well aware that Mr. Archibald cannot file things at this juncture because of the pending stay, which is why we're asking for the reserved ruling on this matter, or that it be made without prejudice to allow Ms. Vallow Daybell to be heard at such time as she can, recognizing that at this juncture, she's not able to be heard regarding this issue. So I did just want to clarify that with regard to those issues that were raised.
And Judge, I would like an opportunity to respond, seeing that it is my motion.
Just go ahead. Yes.
And very briefly, Judge, I would, I believe that Ms. Blake is misinterpreting Rule 14. The rule simply says the court may require the prosecuting attorney to provide all statements that they intend to use at trial. Putting the burden on me to provide those to the judge isn't what the rule says. So at this point, if the court is even thinking that for some reason they shouldn't sever this thing, the burden is on the state. It's not on me, and Ms. Blake putting it on me is inappropriate. It's on them. And they don't get to pick and say, well, we don't think there's any issues there. But the court has discretion. The court can say, I want the statements or I don't want the statements. That's clearly within the purview of the court. But it's not within Ms. Blake to say, well, we don't have any Bruton issues, so we don't need to provide them. That's a total misinterpretation of the rule. The rule requires the state to provide them if this court deems them an issue important enough for them to review. I don't want any delay, Judge. I need a decision one way or the other as to whether this is going to be severed, because I have a significant amount of preparation that I'm going to need to do, and there's going to be an impact which way this goes. And this has been pending this motion's been pending for 5 months, and it hasn't changed in 5 months Ms. Vallow Daybell's position in terms of where she's at. We have no certainty as to where it's going to be in another 5 or 6 months. And I think it's inappropriate to put Mr. Daybell hanging in this situation with the idea that we don't have any certainty as where this is going. Given that, Judge, there's a difference between delay and uncertainty. And given the uncertainty, Your Honor, I would respectfully ask this court to sever the cases.
All right. I appreciate the arguments from everyone. I am going to take the matter under advisement at this time. I'll consider it submitted, and the court will issue a written ruling on the motion.
Thank you, Your Honor.
All right. Anything else we need to bring up on the case this morning, Mr. Pryor?
I don't believe so, Your Honor. Thank you for your patience in this matter.
Of course, thank you, Mr. Pryor. Ms. Blake, anything further from the state?
Your Honor, the state was going to ask, and I think I'd leave it to the court, but I think we may be able to go off the record for this. But the state did just have a housekeeping issue with a hearing that we had set yesterday. We just wanted to clarify something with the court with regard to that setting.
Okay, why don't we go ahead and conclude this hearing? We will go off of the broadcast of the hearing on the YouTube channel. We'll have the court reporter included, however, and let's take up a breakout session where we'll make a transcript of that, and I'll just discuss that housekeeping matter with counsel. So the motion to sever is concluded. If you want to go ahead and stop the live stream, Madam